A horrifying discovery inside a small Ohio home. Officials rescuing 16 children they say were living in deplorable conditions. This afternoon, 4 adults are facing charges, and we have new details about the heartbreaking conditions the children were found in.
The Siders case takes a new turn. You already know the broad strokes of this case. 16 children, a 5-room house on Omer Street in the tiny village of Hamden, Ohio. 4 adults in custody. A description from the state's own Attorney General that the scene was, in his words, pure evil. So we're not going to spend this video re-walking you through the raid frame by frame. Instead, we're going deeper, because the legal fight around this family has just taken a turn that could reshape how this entire case unfolds. A Vinton County judge has now ordered mental competency evaluations for 3 of the 4 adults charged in this case. Not 1, 3. And the way that number grew, in the space of about a week, tells you a lot about where this case is actually headed. Let's walk through exactly how we got here, because the sequence of filings matters more than any single headline. The competency filing. On a Friday in late July, an attorney named R. Lee Roberts, Jr., who represents Gary Siders II, walked into Vinton County Court and filed a motion asking a judge to order a psychiatric competency evaluation for his client. This is a specific, narrow legal request. It is not a plea. It is not an insanity defense. It is a request for the court to pause and formally examine whether Siders currently understands the nature of the charges against him and whether he is capable of assisting his own attorney in preparing a defense. Competency to stand trial is a snapshot of someone's present mental state, not a verdict on what happened at the time of the alleged crimes. Courts treat it as a threshold question. If a defendant is found incompetent, the criminal process effectively freezes until competency can be restored, if it can be restored at all. In the filing, Roberts wrote that his client's competency to stand trial has been raised, and that supporting documents concern Siders' present mental condition and the request for a psychiatric examination. Roberts didn't stop there. He also asked the court for permission to file the motion itself under seal, arguing that it would touch on highly sensitive mental health information and details reflecting his client's psychiatric condition. That's an important distinction to understand, because sealing documents is different from a gag order. A gag order restricts what people involved in a case are allowed to say publicly. Sealing a document restricts who is allowed to see it at all. But here's where the story actually gets more interesting than the initial filing suggested. Vinton County's prosecutor, William Archer, pushed back on that specific request. He filed his own motion opposing the seal, arguing that the competency motion itself didn't contain anything sensitive enough to warrant being hidden from public view. At the same time, Archer made clear the state wasn't objecting to everything. He said prosecutors have no problem sealing the actual results of the competency evaluation, or any of the detailed medical and psychiatric documentation that would eventually support it. In other words, the fight wasn't over whether Siders' mental health records should ever become public. Almost everyone agrees those should stay private. The fight was narrowly over whether the bare fact that a competency motion existed had to be hidden too, and on that narrower question, the prosecution said no. That distinction matters, because it shaped what the judge ultimately did. She didn't grant Roberts the blanket seal he initially asked for on the motion itself, but she did order the evaluation, and, consistent with how these cases are typically handled, the results of it, and the sensitive material behind it, will be filed under seal once complete. So functionally, the outcome lands close to a middle ground between what the defense wanted and what the prosecution was willing to accept. Why this request came now? To understand why this filing landed when it did, you have to look at what came right before it. Just 10 days earlier, on July 14th, Roberts filed a separate motion asking for a gag order in the case. He argued that public commentary from law enforcement and attorneys involved in the proceedings was creating a real risk of prejudicial pretrial publicity, the kind of saturation coverage that could make it difficult to ever seat an impartial jury. The judge overseeing the case, Lena Featherolf Rogers, agreed and approved that gag order. Her reasoning echoed the concern Roberts raised, that public statements about the case could create what she described as a reasonable likelihood of prejudicial pretrial publicity that could affect the ability to seat a fair jury. So in the span of less than 2 weeks, Sider's defense team went from restricting what people can say about the case to asking whether their own client can meaningfully participate in his defense at all, and doing so in a way that keeps the underlying documentation from public view. Taken together, these two filings tell you something about the defense strategy taking shape here. This is a legal team working methodically to control the information environment around their client, while simultaneously raising the most fundamental question a criminal defense can raise, which is whether the person facing charges is capable of standing trial in the first place. It's also worth noting who is not just watching this play out from the sidelines. The prosecution and the court now have to respond to both motions, and the competency question in particular tends to slow everything down. Once competency is formally raised, Ohio courts are required to address it before the case can move forward on the merits. That means depositions, further motions, scheduling of psychiatric evaluations, and potentially competing expert opinions if the prosecution requests its own evaluation, which is common in cases like this. None of that has been filed yet, as far as public records show, but it is the standard next step when a competency question is raised in a serious felony case. 3 competency questions in the same family. Here's the part of this story that deserves far more attention than it's gotten. Gary Siders II is not the only person in this case whose mental fitness has become a live legal issue, and by the time his evaluation was actually ordered, he wasn't even the first. The first competency motion in this entire case came weeks earlier, from Gary Siders Sr., the 73-year-old grandfather. Not long after his arrest, Siders Sr. fell while being transported to a court appearance and was hospitalized. What was initially treated as an injury from the fall turned into something more serious once doctors examined him, and medical staff identified what prosecutors described only as a serious underlying condition requiring specialized care, details that haven't been made public due to medical privacy law. As a result, he was released on a recognizance bond, meaning he didn't have to post the family's standard $300,000 bond, though he was fitted with a GPS monitoring device so his location could be tracked. His attorney, Dorian Baum, filed the motion for a competency evaluation shortly after that hospitalization, and it went further than a simple fitness question. Baum's filing asked the court to examine not only whether Siders Sr. is competent to stand trial, but also whether he could ultimately be found not guilty by reason of insanity, a separate and more serious legal determination about his mental state at the time the alleged offenses occurred, rather than his present ability to understand the proceedings. Baum told a local television affiliate that Siders Sr. showed significant confusion about the legal process and struggled to describe even basic facts about himself, and said he has very significant concerns about his client's competence. The judge granted that evaluation in early July, with the state's blessing, and it remains unclear whether that examination has been completed. Baum has also been the most publicly vocal of the 4 defense attorneys about the broader case, arguing at one point that once all the facts come out, this may prove to be a case built more around poverty than criminal intent. Then, weeks later, came Gary Siders II's motion, the one that made national headlines because of the ceiling fight described earlier. And then, just one day after that, on a Tuesday in late July, came a third. Christina Siders, the 67-year-old grandmother, filed her own motion through her attorney, a public defender named Kendra Roberts. Unlike her son's filing, Christina's motion didn't ask for anything to be sealed. It simply argued, in Roberts' words, that there is reason to believe her client is unable to fully comprehend the proceedings in the court and is unable to assist counsel in preparing and defending her case. Roberts paired that competency motion with a second filing the same day, asking the court to modify Christina's bond from the standard $300,000 down to a recognizance bond, similar to what her husband had already received. In that filing, Roberts described Christina as the only adult who had been caring for the people inside the home, and pointed to documented medical diagnoses and ongoing treatment needs as part of the basis for both requests. As of the most recent reporting, that bond motion had not yet been ruled on. The judge did not sit on the competency questions, though. On the same day, she approved evaluations for both Gary Siders II and Christina Siders, meaning all three requests, one from the father, one from the son, one from the mother, have now been granted. That leaves Elizabeth Siders as the only one of the four defendants who has not asked for a competency evaluation of her own, though her attorney has told at least one news outlet they're considering it. Each evaluation is required to be completed within 30 days of the judge's order, and consistent with how the court handled the sealing dispute, the results themselves will be filed under seal rather than made public. So this is no longer a story about one father's mental fitness. It's a story about 3 of the 4 adults facing 16 felony counts each, all now moving through parallel competency reviews, on overlapping but not identical timelines, in the same small courthouse. Whether any of these 3 conditions are connected to each other in a medical sense hasn't been made public, and nothing in the filings suggests one evaluation depends on another. But procedurally, the court now has to manage 3 separate fitness questions inside a single 4-defendant felony case, which is an unusual amount of complexity, even for a case that was already unusual in almost every other respect. What the case actually involves. Because this update is really about the competency filing, it's worth pausing to reconnect a few key facts about the underlying charges, since those charges are exactly what a competency evaluation would determine whether Siders is capable of defending himself against. All 4 adults, Gary Siders II, his wife Elizabeth Siders, his father Gary Siders Sr., and his mother Christina Siders, are each facing 16 separate counts of felony child endangerment, one for each of the 16 children who were removed from the home. These are second-degree felonies under Ohio law, and the language used in the charging documents tracks almost word for word with the relevant sections of the Ohio Revised Code, meaning prosecutors have not gone out of their way to add dramatic detail to the filings themselves. Each count is tied to a specific child, identified in the paperwork only by initials and date of birth rather than full names, which is standard practice to protect the identities of minors in custody cases like this. The children who were removed range in age from roughly a year and a half to 18 years old. According to Ohio's Attorney General, investigators believe most of them had spent a significant portion of the last several years confined largely to a single room inside the home, measured at roughly 12 feet by 12 feet. Officials have described the conditions inside that room and the home more broadly, in stark terms, saying some areas of the house were so filled with debris that investigators had difficulty physically accessing them. 7 of the 16 children required hospitalization immediately after being removed, and 2 of those were transported by helicopter to trauma centers, an indication of how serious some of the medical concerns were in the initial hours after the rescue. It's worth being precise here about language, because this is a point where the case has generated some pushback. The Attorney General described the children at one point as looking almost feral, a characterization that made national headlines and shaped a lot of the early coverage. But that specific word choice has since drawn criticism from forensic and child welfare experts, who argue that describing traumatized, isolated children in animalistic terms is both clinically inaccurate and potentially harmful to how the public, and eventually a jury pool, perceives these kids. Their argument isn't that the children weren't suffering or in serious danger. It's that the language used to describe them risks dehumanizing victims of alleged neglect, rather than accurately conveying the medical and psychological reality of what prolonged isolation actually does to a child. That tension between dramatic official language and more clinical, cautious expert pushback has become its own subplot in how this case is being covered. The 16 children remain in the custody of the state, where they are receiving medical care, psychological evaluation, and other rehabilitative support. Ohio's government has committed emergency funding, reported to be around $1 million, specifically to support the children's recovery and placement going forward, which gives you some sense of the scale officials believe is required to help 16 kids recover from an experience like this. It's also worth understanding why a case this complicated is being handled out of a county courthouse this small. Vinton County is one of Ohio's least populous counties, and a case involving 4 adult defendants, 16 alleged victims, and now 3 separate competency proceedings is well beyond what a typical local prosecutor's office handles in a given year. That's part of why Ohio Attorney General Andy Wilson's office has stepped in to provide support through what's called the Special Prosecutions Section, a unit the Attorney General's office uses specifically to help smaller counties manage cases that strain local resources. Wilson's office has said this kind of support goes out to close to half of Ohio's 88 counties in a typical year, and has been clear that Vinton County's own prosecutor, William Archer, remains in charge of the case rather than being replaced. The case nobody saw coming until a different investigation started. One detail that tends to get lost in the noise is how authorities ended up at that house in the first place. The search warrant that led investigators to discover the 16 children wasn't originally about the children at all. It was tied to a separate investigation into Gary Siders II himself, involving allegations that he had exposed himself in public on multiple occasions in the weeks leading up to the raid. Court records connect that investigation to 4 separate incidents, spread across late May, roughly a week apart from each other. It was while executing a warrant connected to those incidents that law enforcement discovered the scale of what was happening inside the home. As a direct result, Siders now faces 2 entirely separate criminal cases running on parallel tracks. There's the felony child endangerment case, which involves all 4 adults and carries the possibility of significant prison time given the second-degree felony classification of each of the 16 counts. And then there's a second, much smaller case, involving 4 misdemeanor counts of public indecency, filed against Siders alone on the very same day deputies raided the home. That misdemeanor case was originally scheduled for a hearing, but it's since been pushed back, with the new hearing date set for the middle of August. It's a much lower stakes case on paper, but it's the one that inadvertently led investigators to the children, which makes it more than a footnote in the broader story. The marriage at the center of it all, part of what made this case so unsettling to so many people, isn't just the number of children or the conditions they were found in. It's the relationship between the 2 parents. Marriage records obtained from a courthouse in Mason County, West Virginia, show that Gary Siders II and Elizabeth Siders were married there back in 2008. At the time, he was 18 years old. She was 15. West Virginia law at that point in time allowed marriages involving minors with parental consent, and there was no minimum age floor attached to that consent requirement, which is why a marriage like that was legally possible there at the time, even though it would raise immediate red flags in most other states today. Officials investigating the broader case have specifically labeled it an intra-family or interfamilial case, a term that in this context has been used to suggest that the relationships within the household go beyond a conventional marriage between unrelated individuals. Investigators have been fairly measured on this point publicly, choosing that specific bureaucratic language rather than making more sensational claims. At the same time, officials have also been clear about what this case is not. They've stated directly that they do not believe human trafficking was a factor here, which matters because early online speculation about a case involving this many children in isolated conditions understandably jumped toward trafficking as an explanation. Investigators have pushed back on that theory specifically, framing this instead as a case of prolonged and extreme neglect and abuse occurring within a single extended family unit, rather than an operation involving outside victims or organized exploitation. Records show the family moved around fairly extensively over the years since that 2008 marriage, with ties reported to several counties in southern and southeastern Ohio, including Gallia, Pike, and Jackson counties, along with a reported stint in Wisconsin at some point in the family's history. Officials have said that throughout this period of frequent moves, the family largely failed to establish the kind of medical and governmental records you would typically expect for a household with this many children. Things like consistent school enrollment, regular pediatric care, or standard identification documents. That pattern of moving and apparent lack of a documented paper trail is part of what investigators believe allowed the situation to continue for as long as it did without drawing outside attention. Whale community is reacting. The people who actually lived near this family have had their own reaction to watching this story unfold nationally. One neighbor, who told reporters he had lived just a few houses away for about 6 years, described the discovery as leaving the entire neighborhood in a state of shock, calling it a quiet area and a genuinely sad situation to witness. A worker at a local Dollar General store, who said she had interacted with members of the family regularly over roughly 2.5 years working there, described seeing Gary and Elizabeth Siders come into the store almost every night, sometimes with one of the children in tow, frequently right before closing time. She said seeing their booking photos on the news left her stunned, noting that she had just waited on them as customers only days earlier, calling the entire situation crazy and sad. Even within the extended family, there's been genuine shock. A relative who is married to one of the couple's daughters told a local news outlet that he and his wife had absolutely no idea the situation inside that home had deteriorated to the point it apparently had. He described the family's reaction as horrified and said their first instinct, once the news broke, was simply wondering what they could do to help. He was careful to point out that this branch of the family was, in his words, distant, explaining that they didn't see each other regularly, not because of any particular falling out, but simply because the extended family had grown apart over the years. That detail matters, because it helps explain one of the more difficult questions hanging over this entire case: how a situation involving 16 children inside a single small room could go unnoticed for so long, even by people connected to the family, by blood and marriage. Where the case stands right now. As of the most recent court activity, none of the 4 adults have actually been indicted yet. This case is still working its way toward a grand jury, which in Ohio is a closed, confidential process used to determine whether prosecutors have enough evidence to formally bring felony charges forward. Vinton County, unlike larger, more populous counties in Ohio, doesn't convene grand juries on a constant rolling basis, so there's been a natural lag between the arrests at the end of June and any formal indictment. All 4 defendants did waive their preliminary hearings, a procedural step that effectively sends the case directly toward the grand jury process rather than requiring a separate hearing to establish probable cause first. 3 of the 4 adults, Gary Siders II, Elizabeth Siders, and Christina Siders, remain in custody, each held on that same $300,000 bond, because none of them have been able to pay it. Gary Siders Sr. remains the exception, out on a recognizance bond because of his ongoing medical situation, though he's still required to wear a GPS monitor as a condition of that release. As part of their bond conditions, all 4 are barred from having any contact with each other or with the children involved in the case, which means even setting aside the criminal proceedings, this is a family that has effectively been kept apart since the day of the arrests. Elizabeth Siders has reportedly asked the court to adjust her own bond conditions, seeking release with protective measures like an ankle monitor rather than remaining in custody, though as of the most recent reporting, a judge had not yet ruled on that specific request. Christina Siders' bond modification motion, filed alongside her competency request, is sitting in the same unresolved position. Meanwhile, the competency evaluations for Gary Siders II, his father, and his mother all continue to move through the system on overlapping but separate timelines, each requiring its own examination, its own 30-day window, and potentially its own hearing before the underlying felony case can proceed any further. What happens from here? With 3 of these evaluations now ordered, the next step for each is the appointment of a forensic psychiatrist or psychologist. In Gary Siders Sr.'s case, the court specifically designated the Forensic Diagnostic Center serving that judicial district. Each evaluator meets with the defendant, reviews their history, and produces a report addressing the specific legal standard for competency, which in most jurisdictions comes down to whether the defendant understands the charges against them and is able to assist their attorney in a rational way. In Siders Sr.'s case, the evaluator has also been asked to weigh in on the separate insanity question, and the court's order specifies that if he's found incompetent, the examiner must state whether competency could realistically be restored within a year. If findings from any of these evaluations are contested, which does happen, the court can order additional evaluations or hold a hearing where experts testify and a judge ultimately decides the question. If any of the three are found incompetent, their individual case doesn't disappear. It typically pauses while the state attempts what's called competency restoration, which can involve treatment, medication, or other interventions aimed at getting a defendant to a place where they can meaningfully participate in their own defense. Only once competency is either confirmed or restored can that person's part of the felony case actually move forward toward trial. If someone is found competent, which is the more common outcome nationally, their case simply proceeds as it would have otherwise. Either way, these filings have added real uncertainty to the timeline of a case that was already moving slowly, given the county's limited grand jury schedule, and they raise a question that will likely follow this case all the way to whatever conclusion it eventually reaches. With 3 of the 4 defendants now potentially facing separate competency timelines, does the prosecution try to move this case forward as one unified proceeding, or does it eventually split into separate tracks, depending on who is found fit to stand trial and when? Court watchers following this case closely will be looking for the answer to that question in the weeks ahead, as will the 16 children whose lives were upended the day investigators walked into that house on Omer Street. Why a competency fight like this one draws so much attention, cases involving a single defendant and a competency question are common enough in courts across the country and rarely make national news. What makes this one different is scale. You have 4 adults, all charged with identical counts, all connected by blood or marriage, and now 3 of them facing active questions about their mental fitness to participate in their own defense, with the 4th reportedly weighing whether to join them. From a legal standpoint, prosecutors now have to manage a docket where 3 of their 4 defendants may not be moving toward trial on the same timeline as the 4th. That creates real strategic complications. If Elizabeth Siders proceeds toward trial or a plea while the other 3 remain tied up in competency, and, in one case, potential insanity proceedings, prosecutors have to decide whether to try defendants separately, wait for everyone to reach the same procedural stage, or pursue some other arrangement entirely. None of that has been resolved publicly, and it may not be resolved for months. But it's exactly the kind of complication that tends to stretch a case like this out well beyond what anyone expected in the first days after the arrests. There's also a broader pattern worth noticing in how these defense teams have approached the case so far. Separate gag orders have now been issued, covering both Gary Siders II's case and Christina Siders' case, restricting what law enforcement and attorneys can say publicly about each. Layered on top of that are 3 competency motions and 1 fight over sealing that only partially succeeded. Taken together, these filings share a common thread, an effort, across multiple defense attorneys representing different family members, to limit what the public, and by extension, any future jury pool, gets to see and hear about this case before it ever reaches a courtroom. That's a fairly standard defense approach in high-profile prosecutions, but it's worth watching closely here, given just how much national attention this case has already received. Attorneys representing high-profile defendants in cases like this often argue that pretrial publicity itself becomes a form of prejudice, one that can taint a jury pool long before opening statements ever happen. How much further that argument goes in front of Judge Featherolf Rogers will likely shape how much information becomes public in the months ahead. The debate over language and public perception. Going back to that forensic pushback for a moment, because it's become a meaningful thread of its own in how this case is being discussed. When officials describe the children using language evoking wild or feral animals, it generated enormous engagement online and became one of the most widely repeated details from the entire case. But child welfare professionals and trauma specialists who work with cases of severe neglect have pushed back specifically on that kind of language, arguing publicly that describing traumatized children in animalistic terms doesn't reflect established clinical understanding of how prolonged isolation and neglect actually present in children. Their concern isn't about minimizing what these children may have gone through. It's about accuracy and about making sure that the public conversation around a case like this doesn't end up shaping perceptions of the victims themselves in ways that could complicate their long-term recovery or how they're perceived if any of them are eventually called to testify. This tension between how officials choose to characterize a case for public consumption and how clinical experts believe such cases should be discussed is likely to keep surfacing as this story continues, especially if psychological evaluations of the children themselves become part of the public record down the line. The road to a grand jury. It's also worth understanding why this case is moving as slowly as it has, procedurally speaking, compared to how quickly it exploded into national headlines. Smaller, rural counties like Vinton County simply don't have the caseload volume that larger urban counties do, and their grand juries convene far less frequently as a result. That means a case can sit for weeks between an arrest and an indictment purely because of scheduling, not because of anything unusual happening behind the scenes. Add in 2 separate competency questions, a gag order, and a sealed motion, and you have a case where the procedural machinery is genuinely more complicated than the initial arrest and press conference might have suggested. None of that is unusual for a case of this size. It's simply a reminder that high-profile cases involving multiple defendants, serious felony counts, and now competing mental health questions tend to move on a much longer timeline than most people expect once the television cameras move on to the next story. For now, the 16 children remain the through line that matters most. They are receiving care, they are no longer inside that room on Omer Street, and every procedural development in this case, the gag orders, the 3 competency filings, the grand jury delay, all of it exists in service of eventually determining what happened to them and who bears responsibility for it. That process is simply going to take longer than a lot of people watching this case expected. And the fact that 3 of the 4 adults charged are now moving through competency review is one of the clearest signs yet of just how long a road this case still has ahead of it. If you want to stay caught up as new developments come out in this case, go ahead and subscribe to this channel so you don't miss the next update.